So welcome all to our SCOTUS briefing. I am Kate Carsella. With me is Brittany Maag, Trusted Associate Justice of Ballotpedia's Federal Courts coverage. Welcome, Brittany. We're happy to have you here with us.
Hey, Kate, I am thrilled to be here. And for those tuning in today, you should know that Kate is the steadfast and much beloved Chief Justice of our federal courts coverage here at BP.
You can't see this, but I am blushing. Where's my gavel? Where is that gavel? Okay, so let's see what we have on the docket for today. The court just entered its summer recess, so we have both the 2021 term that just wrapped with opinions and such to review, and then we have the upcoming 2022 term to preview. So we have lots of ground to cover. Shall we gavel in?
Yes, please. There is a lot to unpack.
Yes, indeed. Okay, so starting with the 2021 term, the court just issued its last opinions of the term on the 30th of June. So we've got plenty of numbers to go over. The court heard 68 cases for arguments this past term and then issued opinions in 66 cases. Brittany, what data jumped out at you as you worked through the end of term statistics?
Yeah, well, the first thing that really struck me was the number of opinions the court issued. 66 decisions is the lowest number of opinions in a term since 2007, when we began tracking this data. And this seems to be a bit of a trend in recent years. In the last 3 terms, the court issued fewer than 70 opinions. Prior to that, it hadn't issued fewer than 71. And for anyone curious, the court released the most opinions in this time period, 87, during the 2015 term.
This is a rhetorical question, but so far as I understand, it takes 4 justices to grant certiorari in a case, which means to grant review, that they'll hear it. So I wonder, with the court's membership changes over time, how that would impact this activity.
Yeah, that's a really good point. And I'm sure it would and does affect the cases the court grants. And another interesting statistic was the court's overall reversal rate of the lower courts. According to SCOTUS blog's Stat Pack, the 2021 term saw a nearly 82% reversal rate, which is the first time since we began tracking this data in 2007 that it's been over 80%. This has also been trending up in recent years. In the 2020 term, the overall reversal rate was just over 79%. In 2019, it was around 67%. And in 2018, it was about 64%.
Again, you can't see me, but my eyebrows went up. How did the lower courts do in terms of reversal rates?
Well, the first, second, third, 8th, 9th, and DC circuits all had a 100% reversal rate, meaning SCOTUS reversed every one of the cases it heard from those circuits. All 5 cases the court heard directly from the state courts were also reversed. The 9th Circuit fared the worst in terms of reversals, as SCOTUS heard 12 cases from the 9th Circuit and reversed all of them. The 11th Circuit had the lowest reversal rate, with just 25% of its cases being reversed. The court heard 4 cases from that circuit and reversed 1. Kate, what caught your attention?
This must be the term of 100%, because one thing I noticed was in terms of justice agreement. So when justices vote together in cases and when they issue their opinions, was that according to SCOTUS blog's Stat Pack, Chief Justice John Roberts and Associate Justice Brett Kavanaugh agreed 100% of the time. And they were in the majority the most of any of the other justices on the court, 95% of the time. The last time 2 justices had a 100% agreement rate was in the 2016 October term between Justices Clarence Thomas and Neil Gorsuch.
Right, yeah, I noticed that too. And in fact, Roberts and Kavanaugh have had the highest agreement rate among all justices since Kavanaugh joined the court in 2018, though they've never previously agreed 100% of the time.
They're doing some sorts of mind melds. They're becoming more of the same mind. I also noticed in the Stat Pack that Justice Sonia Sotomayor was the justice who most often had a low agreement rate with the other justices. So her agreement rate with them was the lowest of their agreement rates with all the other justices for the term. So I'll just read off the justices and the lowest agreement rates. So she had the lowest agreement rates with Chief Justice Roberts, 54%, and Justice Kavanaugh, 54%, Justice Gorsuch, 52%, Justice Amy Coney Barrett, 48%, Justice Samuel Alito, 43%, and Justice Thomas, 40%.
Mm-hmm. Yeah, and this appears to be pretty consistent with previous terms, as she's often had the lowest agreement rates with Thomas and Alito in particular.
Yes, I know it's gone back and forth. If you look through the data, it kind of like will alternate a little bit. But let's pivot back a bit to opinion authorship. So Chief Justice Roberts wrote the most majority opinions of the term, 8. Justice Kavanaugh wrote the most concurrences, where he ultimately agreed with the decision, but may have gotten there differently or something like that. So there were 8 of those. And Justice Sonia Sotomayor wrote the most dissents of the term, 24. Just a note that these figures don't include dissents in orders. So like, for example, denials of certiorari, which means that the justice dissents from a case not being granted.
Oh gosh, if only we had time to dig into orders.
Well, we would have to double the time for this, yes.
Yeah, really. So Kate, can you speak to the number of 5 to 4 decisions? That's always a popular stat that people like to hear about.
Yes, so there were 9 5 to 4 opinions this term. Chief Justice Roberts and Justice Elena Kagan wrote the most of those with 2 each.
And what of 8 to 1 decisions?
Oh, yes. Okay, so Justices Thomas, Sotomayor, and Gorsuch had the most lone dissents, 3 each. Justice Breyer was the only other justice who penned a lone dissent, 1, in the case Badgerow v. Walters. That case, just a little context, concerned federal court's jurisdiction to confirm or vacate an arbitration award under the Federal Arbitration Act. And if you want to read more about that, please visit the case page on the website. So I think this might be a good place for us to pause and take a look at Justice Breyers' stats for the term, his final term as an active justice before assuming senior status, which he did on June 30th. Real quickly, senior status is a classification for Article 3 federal judges who are semi-retired. They meet eligibility through age and service requirements, and they will continue to serve on the court and could hear cases. It would be a reduced number, but upon assuming senior status, their seat is considered vacant. They're no longer an active justice, hence you get a replacement.
Right. And so speaking of replacements, Breyer's successor, Associate Justice Ketanji Brown Jackson, received commission on April 8th and was sworn in by Justice Breyer himself on June 30th when Breyer stepped down. Justice Jackson will hear cases with the rest of the justices starting on October 3rd of this year when the next term begins. And then as for Breyer's stats, he wrote 15 opinions during the 2021 term, 6 majority opinions, 1 concurrence, and 8 dissenting opinions. Among his majority opinions was 1 in a 5 to 4 case, Torres versus the Texas Department of Public Safety. Torres concerned a veteran's ability to sue a state for violating federal law. The court found that such a claim could be brought against the state, even if that state did not consent to such a suit.
Looking back at the term and zooming in a bit more, let's talk a bit about some of the noteworthy cases decided this term. I mean, I would argue that all cases before the court are noteworthy, even some that maybe aren't granted, but then we would be talking for days and we don't have that kind of time.
Right, yeah, totally. So I'll start by looking at 2 of the court's abortion-related cases from the previous term, Whole Women's Health versus Jackson and Dobbs versus Jackson Women's Health Organization. Both of these cases originated from the Fifth Circuit. So first, Whole Women's Health versus Jackson was argued on November 1st, 2021, and decided December 10th, 2021. It concerned a Texas law, SB 8, that restricted abortion procedures after 6 weeks of pregnancy and authorized private civil rights of action related to violations of the law. Basically just meaning that private citizens, including those residing outside the state of Texas, could bring civil actions against individuals for aiding a patient with getting an abortion. The bill did not authorize state officials to enforce the law, nor to bring criminal proceedings. Whole Women's Health et al. a group of Texas abortion providers challenged the law, alleging that it violated the Supreme Court's rulings in Roe v. Wade, the 1973 case, and Planned Parenthood versus Casey, decided in 1992, both of which established the constitutional right to have an abortion before the point of fetal viability, approximately 24 weeks into pregnancy. The abortion providers also challenged the state law's provision that it was to be enforced by private citizens through civil lawsuits rather than the state through criminal charges. The court ruled 8-1 that abortion providers may file suit in federal court against certain Texas executive officials to prevent them from enforcing provisions of SB 8. It further held in a 5-4 vote that the abortion providers could not bring suit against state judicial officials to prevent private lawsuits from being tried. So in the second case, Dobbs versus Jackson Women's Health Organization, that case was argued December 1st, 2021, and decided on June 24th, 2022, right at the end of the court's previous term. So for a little background, in 2018, Jackson Women's Health Organization, a clinic and abortion facility in Mississippi, challenged the constitutionality of Mississippi's Gestational Age Act in federal court. The law, enacted March 19th, 2018, prohibited abortions after the 15th week of pregnancy, except in cases of medical emergencies or fetal abnormalities. The US District Court granted summary judgment in favor of the abortion facility, holding that the law was unconstitutional on its face based on the Supreme Court's previous rulings in Roe v. Wade and Planned Parenthood versus Casey. And it put a permanent stop to the law's enforcement. And then on appeal to the Supreme Court, the court voted 6-3 to uphold the Mississippi law and overturn the lower court's decision. The Supreme Court then went even further, and in a 5-4 ruling held that there is no constitutional right to abortion and overruled the Supreme Court's previous decisions in Roe v. Wade and Planned Parenthood versus Casey. The difference in the vote, 6-3 and 5-4, was due to Chief Justice Roberts voting to uphold the Mississippi law, but not voting to overturn Roe and Casey. So, Kate, what cases do you have for us?
Well, first, thank you for going over those with us, Brittany. I appreciate that, going over them in such depth. I know, especially with the votes, when those rulings came down, it was thorny. First case I want to take a look at is West Virginia versus the Environmental Protection Agency. This case concerned whether the US Constitution authorized Congress and gave them the authority to delegate broad regulatory power to the EPA, the Environmental Protection Agency, related to greenhouse gas emissions. So this is an administrative state case. We do have a special team of writers who handles these. I will do my best to go over the details here. The case concerns the non-delegation doctrine, which is a principle of constitutional and administrative law holding that legislative bodies cannot delegate their legislative powers to executive agencies or private entities. So essentially, like, something that Congress should rule on, and it shouldn't be for federal agencies to regulate or control. This is the first time the court formally invoked the major questions doctrine, this case, for the first time, to limit the scope of powers granted to the EPA through the Clean Air Act. The major questions doctrine basically means that Congress can't delegate regulatory decisions of vast economic or political significance to the executive branch, so federal agencies, and this is all under the umbrella of the non-delegation doctrine. The vast economic or political significance comes from the court's ruling in Utility Air Regulatory Group v. EPA in 2014. Quote, "We expect Congress to speak clearly if it wishes to assign to an agency decisions of vast economic and political significance. If the court deems a regulation to be too significant, it will strike it down unless Congress explicitly authorized that particular regulation." So let's see. The court reversed and remanded the decision of the Court of Appeals for the District of Columbia Circuit. So they reversed it and they will send the case back down for further proceedings, holding that Congress must provide clear direction to the EPA rather than a broad delegation of power in order for the agency to regulate greenhouse gas emissions. It was a 6-3 vote. Chief Justice Roberts was writing the opinion for the majority. And then Justice Elena Kagan wrote the dissent. She argued in part that, quote, the court today prevents congressionally authorized agency action to curb power plants' carbon dioxide emissions. The court appoints itself, instead of Congress or the expert agency, the decision maker on climate policy. I cannot think of many things more frightening. This ruling may be extrapolated out and may apply to any federal agency's policymaking. The case was argued on February 28th, 2022, and it was decided on June 30th. Next up, I want to talk about Carson v. Makin. This was argued on December 8th, 2021, late last year, and it was decided on June 21st of this year. So for background, the Maine State Legislature created a tuition voucher program to pay for students to attend public or private schools in order to ensure that school-age children receive a free public education. Maine is largely rural, so this was created in part to help kids get more access. But private schools that were labeled as sectarian by the state were not approved for funding. In 2018, 3 sets of parents sued Maine in U.S. federal court and a district court, alleging that the program requirement infringed on their First Amendment rights, including the free exercise of religion. So fast forward, in a 6-3 ruling, the court reversed the First Circuit's judgment and remanded the case for further proceedings, holding that Maine's non-sectarian requirement for otherwise generally available tuition assistance payments violated the free exercise clause. Again, Chief Justice Roberts was the majority author. Quote, regardless of how the benefit and restriction are described, the program operates to identify and exclude otherwise eligible schools on the basis of their religious exercise. And Justices Breyer and Sotomayor both wrote dissents. In Justice Sotomayor's dissent, she wrote, what a difference 5 years makes. In 2017, I feared that the court was leading us to a place where a separation of church and state is a constitutional slogan, not a constitutional commitment, in the case Trinity Lutheran. Today, the court leads us to a place where separation of church and state becomes a constitutional violation. If a state cannot offer subsidies to its citizens without being required to fund religious exercise, any state that values its historic anti-establishment interests more than this court does will have to curtail the support it offers its citizens. With growing concern for where this court will lead us next, I respectfully dissent. However, also of note in this case, if we go back in time to May 2021, the Maine legislature enacted an amendment to the state's anti-discrimination law prohibiting discrimination based on gender identity and sexual orientation. And this applied to every private school that chose to accept public funds without regard to religious affiliation. So that's a little bit of context that touches on the rulings here and what was at stake. Okay, let's see. I have one more I would like to go over. Oklahoma v. Castro Huerta. This was argued on April 27th of this year and decided on June 29th. At issue in this case was state authority in Indian country and the scope of the U.S. Supreme Court's ruling in the case McGirt v. Oklahoma, which was decided in 2020. That holding was that under the Indian Major Crimes Act, lands reserved for the Creek Nation in eastern Oklahoma constituted Indian country. In this case, in a 5-4 ruling, the court reversed the decision of the Oklahoma Court of Criminal Appeals, which is a state court, and remanded the case for further proceedings, holding that the federal government and the state have concurrent jurisdiction to prosecute crimes committed by non-Indians against Indians in Indian country. Justice Kavanaugh wrote the majority opinion and wrote, this case presents a jurisdictional question about the prosecution of crimes committed by non-Indians against Indians in Indian country. Under current federal law, does the federal government have exclusive jurisdiction to prosecute those crimes? Or do the federal government and the state have concurrent jurisdiction to prosecute those crimes? We conclude that the federal government and the state have concurrent jurisdiction to prosecute crimes committed by non-Indians against Indians in Indian country. Justice Neil Gorsuch wrote the dissent, and there's a quote from that. Where this court once stood firm, today it wilts. After the Cherokees' exile to what became Oklahoma, the federal government promised that the tribe that it would remain forever free from interference by state authorities. Only the tribe or the federal government could punish crimes by or against tribal members on tribal lands. At various points in history, Oklahoma has chafed at this limitation. Now the state seeks to claim for itself the power to try crimes by non-Indians against tribal members within the Cherokee Reservation. Where our predecessors refused to participate in one state's unlawful power grab at the expense of the Cherokee, today's court accedes to another's. Respectfully, I dissent.
Wow. Thanks for that really thorough review, Kate. Those were some really interesting cases. It's interesting to hear the justices' opinions as well. So I will review two more 2021 term cases before we move into our discussion of the upcoming 2022 term. So first off is New York State Rifle and Pistol Association versus Bruin. This case was argued on November 3rd, 2021, and decided June 23rd of this year. At the time of this case, under New York law, an individual applying for a firearms license for general self-defense was required to show proper cause for needing the firearm. New York courts had defined proper cause as requiring the applicant to, quote, demonstrate a special need for self-protection distinguishable from that of the general community, unquote. After being denied a general self-defense firearms license, two members of the New York State Rifle and Pistol Association brought suit in federal court, alleging that the New York law was unconstitutional. In a 6-3 decision written by Justice Clarence Thomas, the Supreme Court agreed that the law was unconstitutional and that the proper cause standard violated the 14th Amendment because it prevented, quote, law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public. Justices Breyer, Sotomayor, and Kagan were the three dissenting justices. And then next, I wanted to discuss Biden versus Texas, which concerned federal immigration law. This case was argued on April 26th of this year and decided June 30th. So in this case, the US Department of Homeland Security, or DHS, implemented the Migrant Protection Protocols, also known as the Remain in Mexico policy, in December 2018 during former President Donald Trump's administration. The protocols required in part that certain asylum seekers stay in Mexico while their asylum applications were pending in the United States. The DHS under the Biden administration decided to rescind this program on June 1st, 2021. The states of Texas and Missouri sued, arguing that the decision to end the program violated federal immigration law and the Administrative Procedure Act, which is a federal law that establishes uniform procedures for federal agencies to issue regulations. The lower courts determined that ending the program was a violation of federal law, but the Supreme Court reversed this decision in a 5-4 vote and held that DHS lawfully ended the program in a final agency action that was consistent with those applicable federal laws.
Thank you, Brittany. And of course, by no means is this a comprehensive list, but we do, for our listeners and folks in the audience, we do post case pages for cases that were granted and the opinions. So please feel free to look through that on Ballotpedia if and when you decide if you'd like. All right, so shall we take a quick dip through the cases on the docket for the next term?
Yeah, absolutely. To date, the court has agreed to hear 27 cases.
Thank you. I know one, I believe it was one, just came through last week.
Yes. Yeah,
yes.
I'll be talking about that one more in a little bit.
Okay, great. Thank you. All right, so I will start us off. Oh, here's our lovely visual of the geographic boundaries of the federal district courts and courts of appeal to just kind of get an idea of where, like visually, where these courts have jurisdiction. So I'm going to talk about Moore v. Harper. This case concerns the independent state legislature doctrine. which theorizes that state legislatures alone are empowered by the Constitution to regulate federal elections without oversight from state courts. As well, it's possible that state governors might lose veto power over new state election laws. So a little bit of background here. November 4th, 2021, the North Carolina General Assembly adopted a new congressional voting map based on 2020 census data. The legislature at that time was controlled by the Republican Party. A group of Democratic Party affiliated voters and nonprofit organizations challenged the map in state court, alleging that the new map was a partisan gerrymander that violated the state constitution. On February 14th, 2022, the North Carolina Supreme Court ruled that the state could not use the map in the 2022 elections and that it was a gerrymander, and then remanded the case to the trial court for further proceedings. And then following that, the trial court adopted a new congressional map drawn by 3 court-appointed experts. On February 25th, 2022, prior to the state's primary election on May 17th, Republican state legislators filed an emergency appeal with the U.S. Supreme Court, with SCOTUS, asking to halt the state court's order until SCOTUS could review the case. The court denied the request. Justices Alito, Thomas, and Gorsuch dissented, and in the dissent and in a concurrence by Justice Kavanaugh, the justices stated that the independent state legislature doctrine was an important question for the court to resolve. SCOTUS granted review in the case on June 30th for this upcoming October term, which starts, as you would guess, in October.
Oh gosh, I will definitely be following that one. That's really interesting. So now I will go over a few more cases that caught my interest in the 2022 term. They're scheduled for the 2022 term. The first is National Pork Producers Council versus Ross. This case was granted on March 28th, and it's scheduled for argument on October 12th, 2022. It concerns the constitutionality of the conditions that California's Proposition 12 imposes on pork producers nationwide in order to be able to sell pork in California. So the legal question really examines whether this California law violates the Dormant Commerce Clause found in Article 1, Section 8 of the Constitution in the way that it affects interstate commerce outside of California. So that should be a cool one to watch. And then next up is a pair of cases, Students for Fair Admissions, Inc. versus the President and Fellows of Harvard, and Students for Fair Admissions, Inc. versus the University of North Carolina. These cases have gotten some attention because they have to do with colleges' use of affirmative action in their admissions policies. And worth noting is that the court originally consolidated these two cases to be heard together in one argument session. But in an order last week, the court separated them into 2 separate cases so that Judge Jackson can participate in the UNC case. Jackson is expected to recuse herself from the Harvard case due to her previous affiliation with that university's Board of Overseers. So for a little background in this case, the plaintiffs, Students for Fair Admissions, sued Harvard University and the University of North Carolina and argued that the university's use of race as a factor in admissions violated Title VI of the Civil Rights Act and the Equal Protection Clause of the Constitution's 14th Amendment. The plaintiffs are specifically asking the court to overrule its 2003 decision in Grutter v. Bollinger that upheld the use of these race-conscious admissions programs so long as they were narrowly tailored for a compelling interest. And then finally, we all know SCOTUS likes to keep us on our toes. And as Kate mentioned, last Thursday, the court accepted an additional case for its 2022 merits docket that came to it on an emergency appeal by the federal government. And that case is United States versus Texas. Now, this 2022 case shouldn't be confused with the United States versus Texas case from the 2021 term, which involved Texas's abortion law, SB 8. This 2022 case has to do with federal immigration law and the executive branch's ability to issue guidance on enforcement of that law. So in a September 2021 memorandum, the Department of Homeland Security set forth guidelines for prioritizing the deportation of non-citizens from the United States. The memo said DHS would focus its efforts on suspected terrorists, individuals who commit serious crimes, and non-citizens caught at the border. Texas and Louisiana challenged this policy in federal district court in Texas, arguing essentially that the guidelines issued by an executive branch agency are contrary to the federal immigration laws passed by Congress. The district court agreed and barred the policy from taking effect nationwide. And then the Fifth Circuit upheld the district court's ruling on appeal. So the federal government went to the US Supreme Court and asked it to overturn the lower court's decisions and reinstate DHS's policy while the case was working its way through the courts. In a 5-4 order on July 21st, SCOTUS declined to reinstate the policy, but did accept the case for argument during its 2022 term. The court stated in its order that it would schedule the case for argument during the first week of December, but as of now, it has not officially released its argument calendar past October. And as an interesting aside, Judge Ketanji Brown Jackson joined Justices Sotomayor, Kagan, and Barrett in dissenting from the order denying the government's request. So in other words, those 4 justices would have reinstated the DHS policy. The vote was the first recorded vote for Jackson as a Supreme Court justice since joining the court on June 30th.
Thank you, Brittany. And also thank you for helping us keep track of all the different United States v. Texas that go on. The court has some more cases scheduled for argument the next term, of course. Would you be able to go over that with us?
Yeah, of course. So, right, as I alluded to a second ago, the court has released its argument calendar for the October sitting. And currently it's scheduled to hear the following cases, although we know that this is always subject to change. So we'll see if this holds up once we get to October.
Yes, always subject to change.
Yeah. So as we mentioned earlier, the court's term is scheduled to start October 3rd, and it has scheduled 2 cases to hear on the 3rd. The first is Sackett versus the Environmental Protection Agency, which involves how the EPA determines its regulatory jurisdiction under the Clean Water Act. And then next on the 3rd is Delaware versus Pennsylvania and Wisconsin, which is consolidated with Arkansas versus Delaware for 1 hour total of argument. These cases are disputes between the states over Delaware taking the unclaimed funds from MoneyGram checks and whether those checks are subject to the federal law known as the Disposition of Abandoned Money Orders and Travelers' Checks Act. Really rolls right off the tongue. This is a case where the Supreme Court is exercising its original jurisdiction, meaning that SCOTUS is the first and only court to hear the case. Then on October 4th, we also have 2 cases currently scheduled. Merrill versus Milligan, which was consolidated with Merrill versus Castor, also for 1 hour of oral argument. These cases concern Alabama's redistricting plan after the 2020 census and whether it violated the Voting Rights Act. And then we have Arellano versus McDonough. It concerns a veteran's disability benefits and whether the deadline for applying for those benefits can be tolled or put on hold if the veteran's disability prevents him or her from applying within the 1-year time limit. And then on October 11th, the court scheduled 3 cases. Mallory versus Norfolk Southern Railway Company will explain whether, by doing business in a state, a corporation consents to personal jurisdiction in that state. And personal jurisdiction just means that a court has the power to make a decision about a party in a court case and then enforce that decision. The second case on the 11th is Reed v. Gortz, which concerns the ability of a criminal defendant to file a claim for DNA testing of evidence and when the statute of limitations for that claim begins to run. And then finally, on October 11th, we have National Pork Producers Council versus Ross. This is one that I went over in some depth previously and concerns the constitutionality of California's Proposition 12. And then finally, to close out its October sitting, the court scheduled 2 cases on October 12th. The first is Andy Warhol Foundation for the Visual Arts versus Goldsmith. And this has to do with federal copyright law and specifically what the law considers a transformative work in defending against an alleged copyright violation. And finally, Helix Energy Solutions Group versus Hewitt. This case concerns the Fair Labor Standards Act and the provision that certain high-earning employees are exempt from earning overtime pay.
All right, thank you, Brittany. Well, folks, that is all the time that we have for today. Please be sure to follow along with our court's coverage by reading our monthly newsletter, Roman Gavel, following Ballotpedia on Twitter, visiting us on our website. And Brittany, thank you again so much for your time and care working on this coverage all the time and also joining me today. Thank you.
Yeah, this has been really fun. And thank you so much, Kate, too. And of course, thanks to all of our fellow judicial nerds out there who joined us today.
Yes. And to our audience, we touched on a lot of topics today. So if you have any questions, please do feel free to email editor@ballotpedia.org. We will be sure to take a look and do our deep dive and get you the answer you need. I also want to put a reminder out there that we at Ballotpedia rely on donations for all that we do. So if you like our work and want to see more of it, please consider donating by going to ballotpedia.org/donate to see the ways in which you can contribute and make our coverage possible. And we thank you for that. If you registered for today's briefing, we'll send you a YouTube link to a recording of the presentation if you'd like to share that with friends or watch again. But thank you all so much for watching. Have a great day. Take care. And for Team Justice here at Ballotpedia, we are gaveling out.